Good evening. This is Making the Case, and I'm your host, Yodit Tewolde. This Friday, June 25th, Derek Chauvin is scheduled to be sentenced in the murder of George Floyd. But until then, we'll take you through what happens between the time a jury renders a verdict and a judge hands down a sentence to give you a better understanding of what to expect this Friday. Back in April, a jury convicted Chauvin of second-degree murder, third-degree murder, and second-degree manslaughter. We'll talk about how much prison time Chauvin faces and what factors Judge Peter Cahill will take into account when he makes that decision. But first, a look back at how we got here.
Step out of the vehicle and step away from me, all right?
I'm moving. Put your hands behind your back. I'm claustrophobic, man. Working with me. God, I'm claustrophobic, man. Please. Please.
Not responsive right now. Child, check his phone. Get off of his neck. The man ain't moved yet, bro. Don't touch
I got this all on camera. Watch out.
He was the judge, the jury, and the executioner all at once, right then and there, when he took my brother's soul from his body.
The killing of George Floyd has brought a torrent of pain and anguish to our entire city.
Walls will not stop us. Fences will not stop us from protesting.
Black Lives Matter!
Black Lives Matter!
Black Lives Matter! Black Lives Matter!
Our hope is that justice prevails and we can all use this as an opportunity to be better.
Simply don't know how they will find people who haven't already formed an opinion.
Morning, members of the jury panel.
Did you see a video of Mr. Floyd being arrested by the Minneapolis Police Department?
Oh, yes. Give you a moment, Mr. McGowan. I'm not sure if there's water as well.
If he doesn't have a pulse, you need to start compressions.
When you couldn't do that, how did that make you feel?
Totally distressed.
If Mr. Floyd would have died that night had he not been subject to the subdual and restraint of the police.
There's no evidence to suggest he would have died that night.
What today remains your opinion as to the cause of death for Mr. Floyd?
So my opinion remains unchanged. It's what I put on the death certificate last June. That's cardiopulmonary arrest complicating law enforcement subdual, restraint, and neck compression.
My concern is that the outcome is going to be the same as it's always been, a cop being found not guilty saying he was just doing his job.
Disbelief and guilt.
Okay. Why guilt?
If I would have just not taken the bill, this could have been avoided.
It's just scary being a black person. Like, how can I not be here?
There's a lot of racism going on in America. If that don't change, it's going to get worse.
We, the jury, in the above entitled matter as to count 1, unintentional second-degree murder while committing a felony, find the defendant guilty.
This is going to be the first in a future of change.
No one should be above the law. And today's verdict sends that message.
Today has been an occasion where people can celebrate, but tomorrow it's back to business.
Say his name, George Floyd. 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 Say his name, George Floyd.
Following the jury verdict, the defense filed a motion for a new trial based on, among other things, allegations of jury misconduct, which the judge hasn't ruled on yet. And the prosecution successfully argued that the judge should consider aggravating factors when he sentences Chauvin on Friday, meaning the former police officer will be eligible for a higher sentence than he would otherwise be. All right, joining me to talk about all of this is veteran prosecutor and BNC's legal contributor, Paul Henderson, who has been with us from the start of this trial. Paul, we're nearing the end here. Let's start at the beginning, though, and break down some of the basic trial concepts for our viewers, okay? A trial is split into 2 stages, right? Also known as a bifurcated trial. So Chauvin was tried and convicted by a jury in the first part, known as the guilt-innocence phase. Now the trial moves to the second stage, which is punishment. Can you explain the difference concerning Chauvin's right to be tried by a jury and his right to be sentenced by the judge?
Sure. So as you said and explained, there are 2 different parts to it. So we've already had the actual trial, and the trial has ended and resulted in the verdict.
but that's not completing things until we have the sentencing. And so the sentencing is the second part of it, where it's either a judge or a jury makes a determination as to the amount of time, the amount of punishment associated with the finding. Now, in this case, Chauvin smartly, I believe, elected to allow the judge to make that determination and not the jury that found him guilty in the first place. I believe he did that because once you have a body that has convicted you, they are more likely to be leaning towards punishment. And I think he thought that he could make a better argument that would be more objective if he made it in front of the judge. And so that's what he elected to do. And that was many of the disclosures and many of the releases that the judge focused on at the end of the trial that we saw already. So what's coming up now is that sentencing part of where we will see what the judge's feeling is going to be. And we already have an indication by the motion that he's granted for the prosecution to depart from the limitation that they have in that state that would have limited Chauvin to a mere 12 years. And I will point out, too, just because we're talking about all of these things in the context of the timeline, this singular incident, because remember, this is just accountability for this one instance. It's not the bigger reform conversation. It's just the accountability for this one incident. Still touches upon other trials that we see for the other officers that have been charged. And so it's still all the same transaction, all the same incident, and we're not finished with it yet. Although what has happened in this case and in this trial for Chauvin is going to be an indication of what we could see in the future unless some sort of plea deal is worked out. And we also don't want to forget that there could be pending federal charges as well that are looming for all of the folks that are involved in the prosecution.
Paul, Minnesota, like most states in the U.S., leaves the ultimate sentence up to the judge. Why do some states, like Texas, allow defendants the option to elect to be sentenced by a jury? And what are the pros and cons for Chauvin?
Well, it's their right? And so when we talk about what we hear in the Constitution, that you are tried by a jury of your peers, that trying by a jury of your peers also contemplates and encompasses being sentenced by them as well. And so you really have to balance as a defendant whether or not you want whether or not you want the jury to come up with and hear all of your priors. And oftentimes this is part of the analysis. Oftentimes part of the evaluation of sentencing contemplates prior bad acts and prior information that wasn't a part of the trial. So as part of the sentencing, many times a jury could be introduced into evidence that they've never seen before, heard before about a specific individual, and they may hear about information about prior bad acts that were sanitized away or restricted from the trial. All of these influence what the outcome could be, and the defendant is empowered to make a decision as to whether or not he wants a juror, a judge, to make that decision, or a jury to make the decision about the sentencing. And in this case, we're specifically talking about Judge Cahill, which he has elected to hear his sentence. And that's why we've had the rulings from Cahill as well, saying that he is going to depart from, or is allowing the departure from contemplation to allow more times, where he will be weighing and evaluating both mitigating and aggravating factors, although he's granted the motion for the aggravating factors. And that's what I think is going to be telling, and what I'm going to be looking for when we ultimately see the full hearing and listen to the testimony and see the pre-sentencing report, if it gets released by Cahill, which I can't imagine that it wouldn't. It should be a public document, at least after the conclusion, that I'm looking forward to seeing what the ultimate determination and the ultimate ruling is going to be in terms of the time.
Well, Paul, let's talk about evidence. You have people asking, okay, well, what can we expect in the punishment phase? People asked why Chauvin's record wasn't brought up in the guilt-innocence phase. People asked, it's certain truths that we know that just can't come in because of the rules of evidence. Explain how that's different in the punishment phase.
Yeah, so in the punishment phase, what you're contemplating is separate from just the incident, and that's what the trial focuses on. Were you guilty for this incident? Now, when at the sentencing phase, it's contemplation of broader circumstances, which is why it will almost feel as though this will be new evidence that's going to be presented to the judge while he makes the determination. And of course, we'll be there to watch all of that. And it should be both testimony and written evidence that gets submitted. So there will be statements and there will be testimonies From the prosecution, it will include family statements from George Floyd and victim impact statements from George Floyd and his family. I'm curious to see, and this is what I'm looking for on Friday, I want to hear what community advocates may be called in to testify. And most importantly, I'm really paying attention to, because what I want to see are police advocates coming in. I want to see the police departments coming in to testify against Chauvin about his behavior, to separate themselves and to redefine what they believe policing should be, which is not what was reflected by Chauvin. So I really want to hear that condemnation, and I want to hear that judgment from law enforcement to redefine the behavior that we saw that was judged in the trial, and that's on the prosecution side. We don't have to wonder as to whether or not Chauvin will be there or not, because we know that it's mandatory in Minneapolis for sentencing. He will be there. I'm curious to hear his statement. What I presume he's going to present is a form of an apology that I don't believe is going to go far enough. And I say that because after reviewing the defense counsel's motions and his statement saying that this was just a mere accident, that this was a training failure, which is an esoteric term meaning that Chauvin was following policy and made a mistake, but it wasn't his fault. There's no scienter or mens rea or mental intent or malice. It was just he misapplied his training. I don't believe that that's the case, and I think whatever apology he makes will be referential to those statements and referential to those motions that his defense counsel has filed on his behalf, which is going to be very disappointing to me. But I think the judge is going to see through all of that and follow the indicated ruling from the prosecution of at least 30 years. That's what my gut is telling me.
So, Paul, people also question why the sentencing was scheduled months after the verdict. You and I know that there's a process called the pre-sentencing report, also known as a PSI, that has to begin. Explain what a PSI is and what compiling one would involve in a case like this.
Absolutely. So there's an agency, and it's typically adult probation in a case like this, that parole or probation officers are involved with. And what they look at are the sum total of the life experience, the sum total of previous arrests, the sum total what's going on with this case in particular, and with this defendant in particular, to look at what his history has been. So what they will be evaluating, as we've talked about and heard in the past, but was not part of the trial, were the previous incidents and allegations against Chauvin that were made against him while he was an officer, for use of force violations, for similar incidents where he was overly aggressive. All of that will go into what they summarize as what their estimation is. And they're essentially, the probation officer that files the pre-sentencing report is essentially a third advocate of what they believe the court should follow. And the court will rely pretty heavily on that argument, as well as the arguments from the defense and from the prosecution. So that's essentially a third advocate that's coming into the courtroom in the form of this report, outlining what they believe should be the sentence recommendation for the judge to follow. That's what the report contains. And it's not necessarily revealed to the public. Judge Cahill reserves the right to make that document public and make it part of the public record. I can't imagine why he wouldn't, but he has not as of yet. No one has seen that pre-sentencing report. I would be surprised if we see the pre-sentencing report before he makes a conclusion. But I'm curious to see what that department has determined would be an appropriate sentence as well.
Well, we will see this Friday, Paul. All right, veteran prosecutor and BNC's legal contributor, Paul Henderson. Thanks again.
Thanks, Yodit.